People v. Collier.
Good afternoon. The Legal Aid Society by Lily Getz on behalf of Mr. Collier. In the context of a nearly...
You wish to save any time for rebuttal?
Oh, I'm sorry. Thank you. 4 minutes, please.
4.
Yeah. In the context of a nearly 6-year delay, all of it completely unexplained and entirely caused by the government...
Counsel, in your proposed multi-factor test, there's a prejudice element, yes?
There is.
Okay. What's the prejudice here?
The prejudice here is a person ending their criminal case, living their life for 6 years with no further contact with the criminal legal system, with a reasonable and understandable belief that they had completely served their entire sentence and that they had satisfied all the responsibilities attendant to that sentence.
But the designation was backdated, wasn't it?
The period of registration
Yes.
ultimately was backdated to the
Right.
period of time when it should have occurred, when the
So
registration
It
requirement.
seems to me that you might have a better argument for prejudice if that had not happened. But why do you have an argument for prejudice given that it did?
Because the prejudice, we can't measure prejudice simply by looking at the outcome of the hearing itself, which we're contesting should never have even occurred. Prejudice has to be viewed with a wide lens here, and prejudice for this person specifically included not just the...
So it's just the lack of certainty. What if you have a defendant who waits for 6 years, or however long it is, and then receives a downward departure? And that downward departure, whatever the resulting designation is, level 1, level 2, is backdated as took place here. Would there still be prejudice in your view?
Well, I think prejudice here really connects very closely with the notice factor that also we're advocating should be part of the consideration.
I'm just asking, is the waiting itself prejudice regardless of the outcome or the backdating in your view?
The waiting, if waiting had occurred, I'm not trying to avoid your question, but if waiting had occurred and the person knew this was this was going to be part of their life, and they were just waiting for it to happen, that would be different than the situation here.
But arguably even more prejudicial in the sense, or maybe not prejudicial, but injurious in the sense that they've got this anxiety about, they're waiting for their hearing, they're not getting their hearing, they don't know what their status is, but where no one is talking about it or thinking about it, that kind of injury is not present, and I'm having trouble understanding what's the prejudice if given the result here. Do you understand my question?
I think so. I mean, if you were looking just at the outcome of the hearing, which it sounds like you're doing, certainly a level 1 is better than a level 2. I'm not arguing with you about that.
So if prejudice is something that affects the weighing of the merits in the proceeding, that's sort of my 2-cent definition of prejudice. Everything worked out great here for your client because they got a level 1 when they were a presumptive level 2.
And nunc-pro-tunc.
And nunc-pro-tunc.
And in part because of that delay, because he had lived his life in a particular way and the court took that into consideration.
That's all true, Judge. But the question here is not whether the hearing that actually occurred was problematic, because the outcome was as good as it possibly could have been at that hearing itself, because he got a level 1 and not a level 2. Level 2 would have required lifetime registration. Clearly, he's in a better position as a level 1 than a level 2. But the question really is prejudice-wise. The question is, what impact did it have on his life as a person who had a reasonable...
What about the fact that if his hearing had occurred when it was supposed to, he would have been deemed, arguably, he would have been deemed a level 2 unless there was evidence to the contrary, and he would have had lifetime, but for the delay, he got the benefit of the level 1 and therefore not the requirement of the lifetime registration.
That's absolutely true, that it looks like on the risk assessment instrument, he would have been graded points sufficient to make him a level 2. We could have, we don't know what the outcome would have been at that point in time, but again, that's really not the question here. The question
Counsel,
is,
we do have a case, sorry, and I think it's Knox, but where we said there is a substantive due process interest in this type of proceeding, and it's in mislabeling or misdesignating someone, and I think that was involving a out-of-jurisdiction conviction or one that arguably didn't fit the scheme. And I understand that substantive due process interest. What is the liberty interest you're arguing for here? That for those 6 years where he was supposed to register, automatically had to register as something, level 1, level 2, or level 3, he had no idea he was supposed to register?
The
I mean,
liberty,
what's the liberty
the
interest?
liberty interest is the liberty interest in living one's life as a free person, unrestricted by
he did.
governmental intrusion.
Isn't that
He
exactly
did.
what he did?
That is, but the question here that I'm asking the court to consider is not whether, again, whether the outcome of that hearing was fair and whether he did better than he would have done if the
What's
hearing
the
had occurred.
harm to his interest in living his life as a free person, and especially for 6 years when he mandatory had to register at least as a level 1, and now what's the harm? That he has an expectation he should just continue?
But Judge, the
And
harm,
for those he's getting credit for those 6 years, even though he wasn't registered.
that's true. But the question here, again, is really balancing, the question is whether it violates fundamental fairness, our idea of fundamental fairness, for the government to, without explanation, without justification, wait 6 years to do something that it should have done, whether the combination of these 4 factors.
Well,
But I think-
isn't the justification that all registered sex offenders get a risk level assessment after they serve their period of incarceration?
I don't see how that justifies their failure to do any of the things they were supposed to do here, including providing him with notice.
Well, you
Maybe I'm
said without
misunderstanding your-
justification, and I'm just saying, one possible justification is that's what the law requires.
That's absolutely not a justification for their failure to do anything here. No one mentioned SORA at any point in time.
No, we've said that if you don't mention SORA at your sentencing, it's not like supervised release. It doesn't matter. You still have to register, right?
I don't know any case where the court has said that the failure to mention SORA,
So,
I mean,
in
the statute-
supervised release, where in many cases we had, where there's a failure to mention that part of your sentence is going to be supervised release, we've said no good, not a valid sentence, right? With SORA registration, we've said failure to mention the fact that you are going to have to register for the rest of your life as at the sentencing doesn't have any effect on the mandatory nature of your registration.
the statute does purport to impose this mandatory registration requirement on anyone who's convicted of a certain list of enumerated offenses. That's not in dispute
And
here.
if I'm the judge and I don't tell you you have to register, you serve your 5 years, and you get out, I believe there have been cases where someone has tried to say, you didn't tell me I had to register, and that's just like supervised release, it's part of my sentence, and we've said, no, you still have to register, even though you weren't told at your sentencing hearing that you needed to register under SORA given the conviction that you had.
I'm not sure that I know of any such cases. I'm not arguing here that that this is actually part of the sentence. It's a separate proceeding that flows, a civil proceeding.
Would that be a potential due process violation then? Because I had served my 5-year sentence and no one told me I was going to have to register when I got out?
I don't know if that would be a separate due process issue. I mean, the question here is what, and in that, I think you're talking about a 5-year prison sentence?
Yeah, let's say I'd served my 5 years, but the judge never told me that I would have to register for SORA, and we've said that's okay. But then can the defendant get out and say, you never told me I had to register at sentencing, and I did my 5 years and I thought I was free and clear, and now you're telling me I'm a lifetime sexually violent predator, level 3?
I don't think so, because the statute actually makes very clear that the proceeding for SORA is supposed to occur shortly before that person's released. Let's say, for example, in your...
I did 4 years and 9 months without knowing that I had to register.
That's a totally different situation than we're dealing with here, and I understand it's a
Yes, I
hypothetical.
know it's different, but why wouldn't that be a due process violation in some
I think it could be, because the person doesn't have knowledge. Maybe it's a basis to vacate their plea because they didn't have knowledge about what the
Well,
entirety
we've
of the
said
plea...
no to that. We've said, let's assume we've said no to that. That's not a basis to vacate your plea.
I'm not sure I'm getting where you're...
So we've said no, it's not a basis to vacate your plea. Judge never tells you you have to register for SORA. You go through 4 years, 11 months, and 2 weeks, and all of a sudden they come in and tell me I'm a level 3 sexually violent offender who has to register make many reporting requirements. And I say, I lived my life for 4 years, 11 months, and 2 weeks, and you never told me I had to register for SORA.
I think that's just too different from the situation we're presented with here, but I think you could still analyze that situation using the multi-factor test that we're suggesting here.
To me that if I'm understanding your concept of prejudice, what you're saying is that learning about the registration requirement 6 years in is somehow more harmful than learning about the registration requirement in a timely manner, even if it turns out that that lapse of time may have benefits with respect to the designation. Do I have that right?
I think that's true.
Why is that exactly? Why is learning, close to or upon release in a timely way that you have to register not as significant or whatever word you want to use, difficult as learning about it 6 years down the road?
I think it has to do with the concept of fairness about the procedures that occur during a criminal case. Like, the statute itself imposes all of these different responsibilities on various government actors to notify the person that is going to be responsible for these registration
I'm
requirements.
not asking, I guess, whether it's okay to delay for 6 years. I'm asking specifically about your concept of prejudice and why it is that learning 6 years in that you have an obligation that you didn't know about at the time of release is meaningfully different.
Because our kind of criminal legal system is built upon the idea that when someone is finished with their sentence and it's over, that they have a reasonable expectation of the
So
finality
it's their
of that
sense
sentence.
of finality. Okay.
Yeah, I think that's a big part of it. And the sense of finality means that you have the right as a free person to know that you've served your sentence, that
Can I
you've
just
completed what
ask-
you owe.
Can I ask a question? I'm wondering why your definition of prejudice is so broad. Like, you have a right to live this life. Usually we look at prejudice specifically, like, was a defendant prejudiced in terms of trying to prepare for a hearing, or maybe witnesses were gone. Like, we very narrowly look at prejudice, and it's tied to what it is that the defendant is seeking to have accomplished and how he was injured by that. Like, this broad sense of prejudice, I was living my life and now you're bothering me because I have to register even though I'm required to register. Like, do you have any authority for that sort of broad reading of prejudice?
I mean, I don't think this court, in the cases that we talk about in our briefs, the constitutional speedy trial cases, prejudice is often measured in terms of the difficulty of preparing for a trial when there's been a lengthy delay. But this court has held that prejudice isn't necessarily something that you can always point to, that sometimes it's difficult to really put your finger on what prejudice is. That's why I think a multi-factor test is so valuable here. This is not just about prejudice to him.
But you agree that prejudice is required?
In
In this
evaluating?
Yes, in
I
evaluating.
think it should be. I don't think there's any harm in using it as a factor, but I think the problem with what the appellate division here did, and I see that my red light is on, but I'm just going to wrap this up. The problem with what the appellate division did here is that it weighted that factor above all others. That's not a
So
balancing test.
consider a number of factors and give them appropriate weight.
Right, and that's the point of a balancing test, is to weigh those factors to figure out on balance what the result should be. And in this case, the appellate division actually found that all of the other factors weighed in favor of Mr. Collier, and I think there's an argument to be made that the factors weighed in his favor for prejudice as well. There's no record support for their conclusion that he had notice or should have had notice, or that there was a reasonable probability that he had notice. That there's no facts and evidence to support that. So I think when you examine the facts here, applying that 4-factor test, the result is that this case should be dismissed, that the proceedings should be dismissed, because the government lost the right to intrude on someone's liberty after this lengthy, unexplained delay.
Thank you.
Thank you.
Good afternoon. Larry Glasser for the Respondent, people of the state of New York.
Could you start with the issue of prejudice?
Yes, absolutely. There was no prejudice in this case for 2 reasons, as Your Honors had indicated in your questioning. The court in this case not only declined to impose 15 points for no supervision.
Is prejudice a fact? in and of itself, is that the be end of all? Or do other factors also have to be weighed?
Well, I think other factors have to be weighed, because whether the court considers prejudice or harm, there's sort of a preliminary issue, which there has to be a deprivation of a right that occurred, of a liberty or property right.
So did the
And-
court below consider more than just prejudice? Did it consider other factors?
It did consider other factors, and one thing that I would note to this court is a
Wait a minute. When you started out with the liberty interest, is your position that he had no liberty interest? Or he had no interest that could be protected as a
A
constitutional matter?
defendant duly convicted of a registrable sex offense, as this defendant was, does not have a liberty interest in not registering.
Well,
and this
I
court
think
has
that-
said-
what about in having a timely determination of their classification?
Well, there might be some time that this court found to be excessive, but considering a level 1 registration is for 20
No,
years.
that was yes or no.
Oh, I'm sorry.
Might there be a liberty interest, or is there a liberty interest in having a timely determination of one's classification?
There's no liberty interest after 6 years in this case, no. Because even if the defendant got a prompt hearing of the most favorable result possible, he would have had to register for 20 years as a result of his
So let
conviction.
me ask you this. Supposing the delay here had been 50 years, so at that point, Mr. Collier is 72 years old before anyone notices, and is that, in and of itself, would that constitute a due process violation if they then tried to start the SOAR hearing then?
I think it could, Your Honor, because as opposing
Could.
counsel mentioned,
What-
there's an
okay.
expectation of finality. Because level 1 is 20 years, I think certainly as long as you're within 20 years, there's no expectation of being free and clear from any consequences of your conviction.
All right, and so when you said could, you mean would, or you're not sure?
Well, I think it would depend on the facts, because, for example, if the crime is so heinous that you would be, say, a level 3 subject to lifetime registration, then perhaps there would be an argument that after 50 years, you're still subject to registration.
What if you
from your
showed
conviction.
that if it had been timely, or at least not 50 years, let's go with 10, that you would have had access to evidence that might have allowed the court to determine that the risk level should not be 3? But now, because of the time that has passed, that evidence is no longer available.
Yes, I think that might be a different situation, because there, and this court has said in Watts, for example, and I think Judge Garcia, this might be a case you're referring to, I think Knox as well, a defendant does have an interest in not being mislabeled or miscategorized, but a defendant, this court need not protect a defendant from an accurate classification. And and there's no allegation in this case that because of the passage of time, records that he successfully completed treatment disappeared, or a character witness on his behalf he would have been able to present, but now he couldn't.
But I
That would
think
be a different scenario.
I think there is an argument that your adversary is making, that living in the world with an understanding that you have no further debt to pay for whatever crimes you've committed is something with some weight to it, and to draw that to a close later rather than sooner, inflicts some harm on the defendant. So do we give that no weight at all in your calculus, or some weight, but in your view is it's not very significant, or it's outweighed by the fact that he ended up with a level 1 designation?
I would say almost all those things. I think it has either.
Well, it's one or the other.
Either
It's some
no
weight
low
or no weight.
But it's certainly in the grand calculus does not get much weight at all, because I think the case, I know Judge Garcia, you were asking, Gravino is one of the cases at least that says the failure to inform a defendant at the time of his plea or sentence that he has to register doesn't negate or undo the proceedings. So the harm or the prejudice that the defendant is actually complaining about here, particularly in their brief,
Counsel,
the
I'm sorry,
stigma-
I don't mean to interrupt, but I feel like I want to lay some ground rules, if it's possible, on this question of, quote, harm and, quote, prejudice, because you just said harm or prejudice. My understanding, and I think we heard something about this earlier, is that prejudice is something that affects your ability, essentially, to get a fair hearing. Something happens or a series of things happen, memories fade, evidence gets lost, whatever it is. Harm is a somewhat broader category, and we heard questions about people living in the world for years and years and years, and all of a sudden finding out that they have to register. And maybe that's a harm, maybe that's not a harm. But do you agree with that sort of distinction, that prejudice is one thing, it's sort of a procedural question, and harm is something more general that might still be cognizable as a matter of due process, but it's not the same thing as prejudice?
I can understand that, Your Honor. I would agree with that. And what I was about to say to Judge Halligan, the harm that the defendant complains of here is the harm from having to register, which flows from the conviction. They have not identified any harm as a result of the delay that occurred. Their
Well,
brief in particular
he's
talks
set
about
up-
stigma.
He's lived his life in a particular way.
Right.
And now if there's public information, right, a public registration, then that is going to potentially upend that life in a particular way, right? He may have employment that now he's going to lose, right? Isn't that also part of the harm?
Well, as you said,
Prejudice
Your
to
Honor,
how will I set up my life? If I'm on the registration, how will I mean, if you didn't have to tell someone because it wasn't public, right? You're now going to have to explain to an employer perhaps that you didn't tell me, I didn't know, I don't want you here.
and perhaps, as you said, it may have. Perhaps in some case there would be harm from a delay. You know, for example, if the defendant had bought an apartment after he got released from jail, or bought a house right next to a school, that by registering he wouldn't be able to live there. He may also have other legal recourse. He'd have, you know, he could sue or seek an injunction or something like that. There's none of that here.
Well, doesn't the fact that one of the Tranovich factors that's being imported into here is just pure delay, and that's different from prejudice, mean that there's a understanding that delay is going to cause some cognizable injury?
Well, what this court had said in Knox is for either a procedural or a substantive due process claim, there has to first be a deprivation. And again, I would argue there's no deprivation here in the first place, but as to prejudice,
Well, but
the
then if that's your position, then with my 50-year example, you would still say, no, sorry, there's no deprivation here.
Well, but again, after 50 years, a level 1 registrant, for example, a level 1 offender would have a liberty interest in not having to register after 50 years.
What about a level 2 registrant?
Again, I think that would be a different issue. A level 2 offender may not. And in fact, they received a benefit of 50 years of not registering and being able to live free of registration when they should have registered.
Suppose that the board had sent Mr. Collier or somebody else a notice saying you actually don't have to register. It's erroneous, but they sent him that notice. And then he lives for whatever period of time, 6 years, 10 years, 50 years, with that expectation, and then somebody decides, oh, wait a minute, that was actually, figures out that was wrong. Your view then is still there's no deprivation, no protectable liberty interest there.
That would be a trickier question, but I think if the government affirmatively tells him he does not need to register, then that might give him an a vested liberty interest because the government had told him he would not be subject to a restriction.
And the remedy for that would be then he doesn't have to register? Or he has to be, I think they called it unclassified, that is to say law enforcement knows, but it doesn't have to go on any public, it doesn't have to be publicly disseminated.
Well, the unclassified determination is something the Fourth Department created in Gregory. That's not existent in the statute or specifically crafted anywhere in the sex offender law. Rather, what the correction law does explicitly say is whether any of the relevant agencies or the court doesn't promptly adjudicate the defendant according to the timelines of the statute, it says that does not relieve the defendant from his obligations to register. It does not relieve the court from adjudicating a risk level.
Would your analysis be different if the designation had not been set nunc-pro-tunc, in other words, backdated, and so then the time ran from the date of designation 6 years later?
I think that could be different, yes, because as I was saying, if 6 years later, for example, he was adjudicated level 1, and if he could show he would have been level 1 in the first place, then for years, let's say 14 to 20 after the adjudication, which would have been 21 to 26, he would have a liberty interest.
Likewise, I think you said the analysis might be different if the defendant could show that the lapse of time impaired his ability to put on evidence or witness or whatever it is.
Yes. Here, the appellate division, which is a fact-finding court, made the determination that the defendant materially benefited from the delay. And I would submit that's either a finding of fact or at most a mixed question, that has ample support in the record, because the defendant did materially benefit two ways. Number one is the court did decline to assess 15 points for a lack of supervision, even though objectively he was released without supervision, and that's because he did live, and as the prosecution conceded, he turned his life around during those 6 years. That he presumptively would have gotten those 15 points, I think, if the hearing was held immediately upon his release, where he was not under supervision, those 15 points would have been assessed, he would have been level 2. The other way he materially benefited, as we've discussed, is that it was non-protonc. So he is not going to be registered. He is not subject to any review any longer than he would have been if he was promptly adjudicated. And in fact, he's a level 1 offender who's only subject to registration for 14 years. That's less registration than any other level 1 offender that I'm aware of. So he has, in fact, I believe the appellate court, the language they used was materially benefited, and that's because the trial court or the SORA court did make him whole from any prejudice that may have been present from the timing of the hearing in this case. But I would submit that, again, in the first place, he had no liberty interest 6 years after his conviction of not being an accurately classified registered sex offender. Moreover, I would note, and this was something that opposing counsel did not touch on, there was no deliberate action in this case to delay the defendant's hearing. And a defendant in their brief on page 20 acknowledges it was negligence by the government. And this court has repeatedly held, as has the U.S. Supreme Court, that negligence or clerical error does not give rise to a due process claim.
I mean, that makes me wonder whether that Tranovich factor actually has any application in a SORA proceeding. Right?
And thank you.
Because, right, there may be circumstances, I would hope not, but there may be circumstances in criminal prosecution where the government might do that.
Right.
But in a SORA proceeding, I can't see that ever happening, really.
And I would agree, Your Honor, and I think that's distinguishable. I believe, Judge Halligan, I believe you asked about Tranovich before, it may have been someone else. That's different because in two reasons. One is there, if it's the prosecution, the DA's office choosing to delay, then they have the consequence of the decision they made. SORA here is not punitive. It's not something sought by the DA's office. It is, this court has regularly said, it's a remedial statute. Its purpose is to notify the community. But also under Tranovich, you don't know what you don't know. When a defendant is perhaps indicted 10 years later, evidence may have been lost that by virtue of 10 years having passed, we don't know what's been lost or what may favor the defendant. Here, we know that he has materially benefited from the delay in this proceeding, and he has not particularly identified, frankly, either harm or prejudice.
More to the point, I think, the things that the board would use or the court would use in making the risk level determination or downward departure are things that are known in the record. Right?
Yes, Your Honor.
So it's static.
And again, here, it's actually better for the defendant than static because he lived at liberty unsupervised for 6 years. He demonstrated that he did, in fact, turn his life around. He got credit for that. He would not have gotten that credit if the hearing was held immediately upon his release on that static record. So if the court has no further questions.
Is prejudice then dispositive?
No, it's not. It would be a factor, but, and I think it's a necessary, I think it's a necessary component, yes. Without prejudice, I don't think there cannot be a deprivation of a constitutionally protected right if the defendant has not been prejudiced.
That sounds like it's dispositive.
And as I'm saying that out loud, I would argue it's dispositive. I think what I was trying to say is it's not the only factor, but I think it would be dispositive. And I think here we have, again, either the factual determination or at least the mixed question finding that there was no prejudice.
Right, so the fact that there is some prejudice, because if there's no prejudice, your position is it's dispositive. But if there was some prejudice, however, whatever prejudice the court might find, I think your position is, well, you're still going to look at all the factors to determine whether or not, looking at these other factors, they
Yes.
should, right?
Yes, because-
they nevertheless should register.
Right, because, then it would be a question of what.
There's been a due process violation. let me
Right,
put it that
well,
way.
it would depend on what the due process violation was, because, for example, if there's a procedural due process violation, a court could vacate the finding and remand it for a new SORA hearing if, you know, if a defendant didn't have counsel, let's say.
Right.
You know, there's no point in doing that here. The defendant got the most favorable result he should. So for the defendant to claim he's somehow entitled to be an unregistered sex offender because we
I'm
did
just
not
trying to understand your position. If there is no prejudice, then there is no claim, right?
Correct,
I mean, that's your
yes.
position. There's no due process
Yes.
violation. But even if there is some prejudice, you're still saying it might still not be a due process violation because it's a multi-factor test.
Yes.
Okay.
And the court would have to craft a remedy depending on exactly
And would
whether-
those be the Taranovich factors, or would it be something else? Because it seems to me Taranovich is addressing a different kind of prejudice.
Yes, well, Taranovich seems to be primarily procedural due process claim of
Well, it's not even
of
the
delay.
procedural, they're both kind of procedural, but Taranovich, you know, that usually involves an inquiry about whether or not you're going to get a fair hearing concerning something that happened in the past. And obviously, a lot of the Taranovich factors relate to how reliable is the evidence going to be about this thing that happened in the past. Whereas the inquiry in SORA is, what risks do you present to the community today?
Right.
So I don't understand why a test that evaluates the procedural fairness of the evidence about a thing that happened in the past relates to a different kind of hearing that's asking a question about something that's going on right now.
I would agree, Your Honor, and I would think for that reason, the passage of time or the delay is much less significant in the SORA context.
Right. So that's a Taranovich factor that, to me, maybe isn't so relevant for this kind of inquiry.
Absolutely. I would agree, Your Honor.
Thank you.
Okay. Thank you very much.
Excuse me. First of all, I don't think prejudice can be dispositive because I think a multi-factor balancing test allows courts to evaluate the facts that present themselves in a variety of circumstances. And courts, the federal courts, have already applied a similar test to this one that has to do with constitutional speedy trial from Barker versus Wingo in other civil contexts, including the context of property deprivations in a civil forfeiture proceeding. So if this kind of a test applies when there's a property deprivation, it should apply with equal force when we're talking about liberty deprivation.
If we're going to a multi-factor test, one thing I've been struggling with here is, we've said many times, SORA, the purpose of SORA is protect the community, right? Community safety. How do we figure that here? And I know seriousness of the offense means something very different in the Taranovich context, right? It means how long would it take you to put this thing together and go forward with the prosecution. But, for example, if you had someone whose crime classified them as a level 3 sexually violent offender, and for some reason when they get out of serving their time, they are not required to register for 5 years, and that defendant then comes in, they realize it, and says, I was living my life, I had a job, I was counseling children, and now you're going to make me register as a sexually violent offender, level 3, and I'm not going to be able to do that. How do we factor in the risk now for someone who, assume, would have a lifetime registration as a sexually violent offender and severe limitations on their contact and their ability to have jobs where they had daily supervised contact with minors, who now is saying, but I've done that for 5 years and I have an expectation I can do it forever?
Well, I think this court is clearly free to decide what the factor should be in that multi-factor test.
So
And I
would you
think,
agree that there would be some public safety factor here?
I mean, if the court wants to consider that, I think that could fit into the prejudice prong. The seriousness of the offense could be considered in terms of prejudice overall to the community in addition to prejudice to a defendant. I don't think it should be a separate factor. I think it would be weighed too heavily probably in a situation like that. But I think prejudice is sort of a comprehensive factor that can account for a lot of different pieces of the puzzle. But I want to emphasize here that we're talking about a misdemeanor offense for which a person served a year in jail, was released.
No, I'm just trying to figure out what the test would be generally.
Sure.
I
And I think,
understand this is not that case.
right, this is absolutely not that case, and I think it's important for us to remember what case this is. This is a case where an individual served a misdemeanor sentence, was released after serving that sentence with no further issues, and to suggest that 50 years down the road, or even 15 years down the road, there's got to be a point at which the government can't simply forget about things.
Even though it was a misdemeanor, would you look into the underlying facts as to with respect to the risk, the harm that occurred?
I think the other piece of this puzzle, though, is that we do have facts here that show that the risk to the community, as measured by what happened over those 6 years, we know
What about
that,
what happened that caused the conviction in the first instance? Is that to be weighed in at all?
I mean, I don't think so. SORA.
So you don't look at the nature of the offense at all?
I don't think it makes sense, because we're not talking about punishing somebody for that conduct. What we're talking about is
But isn't it a risk factor, depending upon what occurred?
the facts of a case, the facts of a
The facts of a
conviction, sure, are part of the risk assessment instrument, if that's what you're asking about.
Yes.
And again, if the court wishes to consider the seriousness of the harm in the underlying offense.
So
as
it
part
could be serious even though it's classified as a misdemeanor? Because
Sure.
you can plead cases down even though the offense, if it had gone to trial or indictment, could have been a higher charge, right?
Sure, but we don't know, I mean, there was no indictment
No,
in
we
this
don't.
case.
But I'm saying, so that's why factors, plural.
Makes sense. Yes, I think that's really the bottom line, is that factors make sense because we're trying to figure out in a particular circumstance what's fair, what violates our understanding of concepts of fundamental fairness. A defendant has an interest in notice. Notice is a crucial part of our constitutional law, the right to know who the witnesses are against you at a trial, the right to know what the
But you're not
elements of
claiming
charges
that
are.
he was put in a worse position because, to be able to argue to the court whatever risk classification he should or should not be designated as, right? You're not saying he was put in a worse position after 6 years.
The delay didn't make it worse for him to adjudicate
To argue
that
whatever he was
actual-
going to argue, correct.
Sorry?
To argue whatever he wanted to argue to the court with respect to his classification. He
Well,
wasn't put in a worse position because it took 6 years.
Right,
As
he had-
opposed to someone who might, the hypothetical we were talking about before, might be put in a worse position because the evidence is no longer available that they wanted to rely on.
Sure, and in that circumstance, that person could present that evidence in this
Yes,
multi-factor
but I'm just
balancing
saying
test.
that's not your client.
No, he was objectively able to show these very favorable facts that inure to his
It
benefit.
helped him. The 6-year delay in that way helped him.
If you're examining, right, just
No,
what
I
happened at the
understand you
hearing,
want us to
yes.
step back from that.
Right.
But you agree that that was helpful to him.
Yes, but I want to talk very briefly about the negligence. You know, my adversary talked about how this is really about negligence. Negligence can never cause a due process violation. This is not about negligence. This is not about a single act. The cases having to do with substantive due process violations and how negligence takes it out of that scheme, those have to do with affirmative acts by an individual. And those affirmative acts, if they're negligent, may not shock the conscience. But we're talking about the compounding of multiple failures over and over a period of years. SORA doesn't just exist in a vacuum. It only works, it only does something if the individuals charged with administering it do what they're supposed to do. And notice is a crucial part of that.
Could you just explain what the multiple failures were? Because I don't know. I just assumed someone early on, as he was getting ready to leave prison, jail, just made a terrible mistake, and this fell under a table or something like that.
Right, so it wasn't just that one failure, because that certainly does.
So what else was there?
So there are multiple failures here. One of them is the prosecution's failure to say anything about SORA at any point in time during the proceedings. Another failure is the court's failure to certify him as required by statute. These are statutory requirements.
Wasn't certified as a sex
Not
offender?
certified, no.
At time of conviction?
Never. So that's another failure. No one from the court staff brought it to the judge's attention, not a clerk, not a court officer, not a court attorney. Nobody brought the case back later on and said, oh, wait, we forgot to do this crucial thing. He went and served a jail sentence in the City Department of Corrections. The Department of Correction, the facility that's holding an individual serving a sex offense sentence has an independent obligation to notify that person about what their registration requirements were and to produce that person for the SORA hearing before the expiration of their jail sentence. That didn't happen either here. So, and beyond that, after the person's released, they have a criminal conviction. That information goes to the Department of Criminal Justice Services, which is responsible to be the repository of criminal justice information. They know the person's been convicted of a sex offense. They know the person never had a SORA hearing. They didn't do anything either. And then beyond that, the Board of Examiners of Sex Offenders, I don't know the inner workings of that agency, but they did nothing either. So this isn't about negligence. It's not about one person dropping the ball as a person's getting released from jail and not doing what they were supposed to do and excusing that. This is about egregious compounded failures by the government to do anything to either let Mr. Collier know that he had this responsibility or...
Is this an aberration, or does this happen with frequency?
Honestly, I was wondering that same thing. Like, how frequently is this really a problem? In my office, since I briefed this case, 3 of my colleagues have reached out to me about SORA hearings that they were doing, saying, can I see those, I can't share the briefs with them outside because they're sealed, but, what kind of arguments can we make? I have a case where
We're talking about similar delays. If you can say, if you can't, I understand.
I'm sorry that I don't know the exact details about those delays, about how long they were, about what explanations there were for them. I know one of the cases involved somebody who had a second SORA hearing, and that triggered the understanding that they had failed to do one on a first conviction. I don't know the lapse of time there, but, one of them, the case was dismissed because of the delay. I don't know what test the judges used in those circumstances, but that's why we need a test that makes sense, that's easy to apply, that allows balancing of multiple factors. This is absolutely not a strict aberration. What I think is aberrational in this case is the absolute failure to notify him. And the government had an ample opportunity to explain why there was a delay or why they didn't notify him. They did nothing in the trial court. So those are facts that this court, I think, must consider in deciding whether this is the kind of delay that deprives the government of the ability to act to deprive liberty in this case. Thank you.